In 2022, the New Jersey Attorney General initiated an investigation into a religious nonprofit called First Choice Women's Resource Centers. That investigation hinged on a sweeping demand for the identities of the organization's private donors. The state subpoena commanded the production of 28 distinct categories of documents. It explicitly targeted the names, physical addresses, and phone numbers of nearly everyone who had financially supported the group over a multi-year period. 2 days before the deadline to hand over those records, First Choice went to federal district court. They filed a pre-enforcement challenge under 42 U.S.C. Section 1983 to block the subpoena entirely. Their argument was direct. Complying with the state's demand would expose their supporters to government scrutiny, irrevocably violating their donors' First Amendment rights to free association and anonymity. This rapid standoff immediately forces a collision between First Amendment privacy protections and the strict procedural requirements of Article 3 standing. The district court dismissed the lawsuit. Their reasoning rested on the fact that the state had not yet gone to a judge to compel compliance. Because the subpoena was unenforced, the court ruled the NGO had suffered no injury in fact. A divided panel of the Third Circuit affirmed that logic. They insisted the constitutional claim simply lacked ripeness until the state actually initiated formal enforcement proceedings to force the handover of the documents. The Supreme Court reversed that decision in a unanimous opinion, completely rejecting the lower court's reliance on pending state enforcement. Justice Neil Gorsuch explained that in First Amendment contexts, the mere issuance of an investigatory demand targeting protected association constitutes an immediate injury. The court's ruling establishes a firm boundary. Unenforced does not mean uninjurious. This finding forced a direct examination of the state's central argument. A document without the immediate power to compel cannot cause a legal injury. To understand the court's ruling, we have to look back to the foundational 1958 precedent of NAACP v. Alabama. There, the court established that government-compelled disclosure of affiliation restricts the freedom of association. Stripping anonymity leaves dissident groups extremely vulnerable to marginalization and outright suppression by the majority. The modern court reaffirmed this in Americans for Prosperity Foundation v. Bonta, noting that demands for private donor information inevitably deter First Amendment rights. Across these cases, the threshold question is rarely whether privacy was actually breached. The threat of a breach alone creates a chilling effect severe enough to constitute a concrete harm, allowing a group to sue immediately. The Attorney General argued his subpoenas are non-self-executing. Without a judge's enforcement order, he claimed the document imposes no legal duty. The court rejected this. The subpoena's explicit warnings of contempt induce an immediate objective chill, regardless of a judge's intervention. The opinion cites a well-known legal metaphor. The true value of a sword of Damocles is that it hangs over you, not that it drops. Justice Thurgood Marshall originally deployed this framing in 1974 to describe the heavy psychological burden and self-censorship caused by impending government action. An objectively reasonable organization will alter its protected advocacy, knowing it sits in the government's crosshairs. That behavioral shift fully satisfies the Article 3 injury requirement. The lower courts arrived at their flawed conclusion by relying heavily on older administrative law precedents, specifically a case called Reisman.
Reisman dealt with equity practice and IRS summonses, requiring plaintiffs to wait for enforcement because they had an adequate remedy at law. But First Amendment targets suffer an ongoing chill while the demand remains outstanding. The state also compared this to Laird v. Tatum, where plaintiffs feared a general intelligence gathering program. But First Choice didn't express a subjective fear. They received a targeted demand for their records. Administrative precedents governing tax documents cannot be blindly mapped onto First Amendment associational standing. Speech is uniquely vulnerable to delay. The damage occurs the moment the state asks the question. The Attorney General's second defense centered on a concession. He explicitly allowed First Choice to receive anonymous donations through one specific approved website. The state argued this narrow carve-out meant organizations' associational rights were not fully burdened, rendering their claim of constitutional injury moot. The court dismissed this logic. A partial restriction on how a group interacts privately with its donors is still a constitutional injury in fact. Validating this defense establishes a dangerous precedent. It allows the government to force disfavored groups' associational activities into narrow, state-preferred avenues. Justice Gorsuch summarized it directly. A government that takes 3 limbs but spares the last imposes a severe injury all the same. Mitigating the damage does not negate its existence. As a final defense, the Attorney General offered a state court protective order, ensuring donor names would stay entirely out of the public domain. Relying on the Shelton precedent, the court rejected this arrangement. Mere assurances of confidentiality do not eliminate the chilling effect when a group is forced to hand over private data to a hostile official. The court acknowledged a practical modern reality. Data systems are fragile. Hacks and leaks can easily and instantly thrust confidential data into the public sphere. But even removing the threat of a leak, the pressure to avoid displeasing the demanding official is constant and heavy. The chilling effect originates from the government's knowledge and possession of the list itself, not merely the risk of public exposure. This brings us to the underlying federalism anxiety that haunted the lower courts. Why is it legally permissible for a federal court to interrupt an ongoing state investigation? The answer lies in the statutory architecture of 42 U.S.C. Section 1983. Congress enacted that statute specifically to guarantee a direct federal forum for citizens facing constitutional deprivations by state actors. Forcing a litigant to fight the subpoena in state court creates a preclusion trap. If a plaintiff loses the enforcement battle there, it triggers res judicata, permanently barring them from ever bringing their federal claim. Requiring state court exhaustion hollows out the promise of Section 1983, destroying the federal safeguard built to prevent state overreach. Ultimately, the Supreme Court reversed the Third Circuit's ruling and remanded the case down for an actual merits review. This decision provides 3 hard rules for litigators. First, non-self-executing state demands for First Amendment data inflict immediate Article III injury upon issuance. Second, promises of confidentiality or partial exemptions may mitigate the scope of the damages, but they do not cure the underlying standing to sue. And third, Section 1983 plaintiffs facing targeted constitutional burdens do not need to exhaust state administrative or judicial enforcement processes before seeking federal relief. In the architecture of associational standing, the issuance of the demand is the strike, and federal courts are